thanks everyone for joining. This is Susan Ebersole with Latham & Watkins. We also have Juliana Stewart from SAFE on the phone. Juliana, I think you wanted to say a few words to get started.
Sure. Thanks, Susan. And I'm assuming you can hear me?
Yes.
Okay, great. So I just wanted to, this is Juliana Stewart with SAFE. Just wanted to welcome everyone onto the line. Thanks so much for joining us. I think most folks are probably familiar with SAFE, but to anyone from our partner organizations who might be on the line, just wanted to offer a little bit of context about this project and the content that we'll be covering on the webinar today. So SAFE, which most of you know is a collaborative of now 13 nonprofit housing providers, has been working with Latham & Watkins to explore privacy issues related to the collection, usage, and storage of resident data, specifically in the context of service-enriched housing. So this webinar is one product of that work, and it's an effort to inform folks who are working in the field in resident services or property management, as well as folks who might serve them regionally or at the corporate level, about some of the best practices to consider when handling potentially sensitive resident information. So on behalf of SAFE, I just wanted to thank everyone for joining us, and huge thanks to Susan Ebersole and the team at Latham & Watkins for all their great work on this. And I'll hand it over to Susan to get us started.
Thanks, Juliana. And I'm going to press my special code, which mutes everyone else so we don't get any background noise or echoing. I'll take it off in the event that there are questions.
All participants are now in listen-only mode.
All right. Great. Thank you, everyone, for joining. And thanks, Juliana. This is Susan Ebersole. I'm in the Washington, D.C. office of Latham & Watkins. I focus my legal practice on information privacy and security issues. I typically work in the healthcare arena, but I'm also a certified information privacy professional, which is a fancy-ish designation saying that I have studied and passed exams in certain privacy and security areas. So we've been working with SAFE for quite some time on these issues, working on ways that SAFE can help its members kind of organize thoughts and institute best practices, as Juliana said, with respect to the collection, use, disclosure, and disposal of resident data that may, in certain cases, be collected under federal housing programs. It may be required to be collected for certain purposes, but then, resident services may want to utilize that data always for helpful and good purposes, but it raises a lot of questions on use limitations and requirements for the privacy and security of the data, particularly when, as Juliana mentioned, that data is sensitive in nature, and we'll get into what kind of data that might be as we go through the presentation. So first I wanted to talk about the types of sensitive residential data that may be collected in the affordable housing context. These should all be very familiar to you. And the first question to ask when you're dealing with a privacy question is, what type of information is it? Is it identifiable personal data? And we'll get into what that means later on. And does it deal with a particular subject matter that is sensitive? A lot of times you may have that sort of ick factor about something. You just know that it's not quite right, even though you're not sure why, to share this kind of information without the knowledge of the individual whose information it is. You're not sure if you need to give notice to the individual, if they need to sign a consent. You're not sure if the individual themselves should be able to access this information. So those are all issues that we're going to deal with in this presentation. And I neglected to say at the outset that I'm a lawyer and I'm SAFE's lawyer, but this presentation is not meant to be legal advice to you. It is an informational presentation. So I'll be speaking at a high level and with some hypothetical fact situations, but in no way is this meant to be legal advice that you should rely on. That's my little lawyer disclaimer that I'll give at the outset. So the first type of sensitive residential data that we see being collected typically is financial information. This is something that I'm sure is going to stick out at you. You may have financial account information, such as whether a resident has a bank account, with what bank, whether the resident doesn't have a bank account, is paying with money orders. You would have access to the tenant's rent payment history, potentially income and employment information. And the reason that you have this, obviously, is it's often required to be collected. The second type of information that we think of as sensitive in nature is health information. Always identifiable to the individual, this information is considered sensitive and may be subject to certain laws. So health information is information about the person's mental or physical health status or their treatment. The fact that they have been to an ER a certain number of times, whether or not they have a primary care provider, who that primary care provider is, things like depression screenings that may be done in conjunction with residential services. This is what we think of as health information. A subset of health information that is considered particularly sensitive would be substance abuse history or treatment information. That includes mental health information, any information about sexually transmitted diseases or status of HIV status or anything like that is also considered particularly sensitive. Again, it's that kind of gut test of, is this something that would be embarrassing or distressing to the individual if it got out. And then another part of health information is any information about payment for health care services. So this would include enrollment and insurance programs, benefits information, and any type of information about payment. More sensitive residential data that is sometimes collected is education information, such as the education level of adults, or sometimes that can be information about children, which we consider particularly sensitive, enrollment in Head Start or grade advancement for children. And then, information about children I mentioned is particularly sensitive. That could be information about their health, wellness, welfare, or education. And then there are kind of these last categories of housing stability and community engagement information, which are maybe less sensitive, but we still consider them personal information, and you may have questions about how to use, share, and dispose of that information. So I think, when you have that gut feeling of we're collecting sensitive information, we may be collecting it for one purpose, but we want to use it for another purpose. It's financial data, it's health data, it's education data. Even if you have no legal background, you have that gut feeling that this information is personal. There has to be some privacy rule. People have a right to privacy. What is legally required of you as a housing provider. I know, particularly with health information, a lot of people know about HIPAA. Every time you go to the doctor's office, you get your HIPAA notice of privacy practices. You have to sign that you know about it. People throw around HIPAA a lot as a reason for why they can't or shouldn't share health data. Really, in reality, HIPAA only applies to certain types of entities, which I'll get into in a minute. And similarly, most data that is collected in the residential services context, because it's collected by housing providers directly from tenants, is not federally regulated. So typically, there would not be a federal law that would require certain things of you or prohibit the use or sharing. However, we have a set of best practices in the privacy arena known as Fair Information Practice Principles, or FIPS. And these laws were developed these practice principles, not laws, were developed in the 1970s and have evolved, and they're really that common sense gut feeling about protecting privacy that fill in the gaps where the laws in the United States particularly might not apply. So I'm just going to do a brief overview of the federal laws that do apply to these types of information. As I said, most of these will not be applicable in this context, but I think it's useful to understand a little bit more about them, so I'm going to go through them quickly. Financial information mostly is regulated by the Fair Credit Reporting Act, or FCRA, which promotes accuracy, fairness, and privacy of personal information assembled by credit reporting agencies, or CRAs. And I'm going to flip forward. We've come up with this, we call it a decision tree, and these will be available, I believe, through SAFE after this presentation. But this gives you a little more detail about what credit reporting agencies are and how FCRA might apply. You can see through the decision tree that typically if you as a housing provider are collecting information directly from the tenant, you're not getting it from a credit reporting agency or providing it to a credit reporting agency, likely FCRA is not going to apply to that financial information. The second subset of information that you may be collecting is health information, and this is that HIPAA trigger that so many of us worry about. First of all, health information is only potentially regulated if it is identifiable to the individual. So that is a gray area of what identifiable means. You may have household level data, you may have building level data. The test here, and I'm going to flip forward again, is whether it identifies the individual or for which, if there's a reasonable basis to believe that the information can be used to identify the individual. HIPAA lists 18 different identifiers which are useful in determining if health information is identifiable, even if you're not really working under HIPAA. And some of those may not be things that you would immediately think of, like zip code can be considered identifiable if less than a certain number of people live in that zip code. So health information that's identifiable to the individual can be federally regulated by HIPAA, which stands for the Health Insurance Portability and Accountability Act of 1996. But HIPAA only applies to certain kinds of entities that maintain or collect health information. HIPAA applies to entities known as covered entities, which are typically healthcare providers or health insurance plans. Healthcare providers are doctors, hospitals, and there's a long list under the Medicare regulations of who counts as a healthcare provider. I know that some affordable housing providers work in conjunction with healthcare providers or have them on premises, and if that is you, then you would need to consider whether you might be subject to HIPAA. Something that's not on this slide is that if you're a healthcare provider, you're only subject to HIPAA if you submit claims for insurance or equivalent encounter information electronically in the regular course of business. So it may be if you're providing free services and not doing any kind of claims transactions that you are not a covered entity under HIPAA. But again, that would be a fact-based scenario where you would need to consult your own legal counsel. So HIPAA also applies to health insurance plans, and it applies now to service providers working on behalf of the healthcare providers or insurance plans who access protected health information or identifiable health information on behalf of their work for those providers or plans. So again, if you are a residential services provider and you are receiving information, health information from your tenants directly, you are likely not regulated by HIPAA unless you fall into one of those buckets. If you're receiving it from a healthcare provider, It would be dependent on whether you're working on behalf of the healthcare provider, which you would likely know. You would have some kind of services agreement. There's an agreement called a business associate agreement that you would be signing with them if you were providing these services that make you subject to HIPAA. If you're kind of working in a partnership on behalf of your tenants, it's likely that you still would not be subject to HIPAA, but again, fact-based scenario, and that's something that you would need to figure out. Additionally, there are state medical information privacy laws, just to confuse the matter, which sometimes apply more broadly than HIPAA to entities that maintain any kind of medical information. Which state law applies depends on which state the individual resides in. So obviously you are providing residential services, so you would know where your tenants reside, and that state's law would apply. Other laws that apply to different buckets of information. Education information is sometimes protected by the Family Education Rights and Privacy Act, known as FERPA, but this only applies to educational records maintained by schools that receive federal funds. So here we have another decision tree asking, whether or not FERPA might apply to education records that you might maintain. If you got them from a school that received federal funding, then you may have to worry about FERPA. Information about children can sometimes be considered especially sensitive, as I mentioned earlier. There's something called the Children's Online Privacy Protection Act, or COPPA, which protects the privacy of information about children on the internet. It prohibits website operators from targeting children who are under 13 years old. Likely you will not have to worry about this, but it's something to consider if you ever engage a website or anything on the internet, a mobile app, to provide services. And then we have the last bucket of housing stability and community engagement information. In the United States, as you can see, we have these various laws that apply to various subject matters of information, and the housing stability and community engagement information doesn't typically fall within any of these buckets that would be federally regulated. So why do we worry about it? That gut feeling has a name, and it's the Fair Information Practice Principles, or FIPS. FIPS are a set of internationally recognized practices for addressing the privacy of information about individuals. As I mentioned earlier, they began in the 1970s and actually originated from what was then the U.S. Department of Health, Education, and Welfare. But they've since evolved and have been adopted by different countries in different forms. They form the basis for the EU Data Protection Directive, which is known to be one of the strictest privacy regimes and applies to all personal data or identifiable information, no matter what the subject matter is. That's if you're in the EU. They provide the underlying policy for many national laws, including the EU laws, which is a collection of countries addressing privacy and data protection matters. And here, they are used as a set of best practices where sensitive personal data is collected, but no legal regime applies. FIPS is comprised of 8 principles. The first is transparency, which means that organizations should be transparent, i.e. notify individuals regarding the collection, use, sharing, and storage of personal data or identifiable information. This is also known as the notice principle. The second principle is individual participation, which means that individuals should be involved as much as possible in the process of collecting their personal data. So this gives individuals the opportunity for choice, which is to consent to the collection of their personal data, to opt out of using their personal data, to access personal data that you may hold about them and correct it if it's wrong or get it back from you if they don't want you to have it anymore. The third principle is purpose specification. And this, I think, will come up a lot in your context where you need to articulate why you are collecting the data and the purpose for which you're going to use it. So for instance, if you collected data in conjunction with an application for a lease, and then you want to use it later for resident services, the best practice would be to articulate at the time of the collection that the data may be used in the future for other purposes, and to articulate as specifically as possible what those purposes are. The fourth principle is data minimization, which means that you really should only collect the information necessary and directly relevant to accomplish your purpose that you articulated in your purpose specification. This is meant to prevent organizations from just being data hogs, essentially, and maintaining tons of personal information about people to use for any purpose down the line. You want to really try to streamline that as much as possible, even if it means, having to go back later and get more data, which I fully understand can be harder than it sounds. I think we're on the fifth principle, is use limitation. So that goes hand in hand with data minimization and purpose specification, that organizations should only use personal data for the purpose that was specified originally, and any sharing should be compatible with the purpose for which the data was collected. The last three principles go more toward the internal storage of the data and organizational structure. So the sixth principle is known as data quality and integrity. It's not just about maintaining the confidentiality of data, but also making sure that what you have is accurate and true and timely, that it's not out of date. If you're going to be, compiling information on the data, it should be an accurate representation of what the data you have is. That also goes hand in hand with access, that people should have the right to see what you have about them, access it, and correct it if it's not accurate. Security is about protecting that data that you maintain through appropriate safeguards, and that applies to data in any form. You think of security safeguards as being electronic, but you also should consider physical safeguards of any paper data, having locked offices, having locked cabinets, key cards for access if you maintain sensitive information about individuals. That also applies to disposal of information, no putting financial records out in a dumpster out back where anybody could access them. You want to be shredding them, etc. The last, fifth principle is accountability and auditing, which really is about kind of privacy from the inside out, from top down and bottom up in the organization, creating accountability in your organization for complying with these principles, providing training to employees. This may not be something that, depending on your daily job function, that you're responsible for, but it's something to keep in mind as we think about how to integrate these FIPS principles into your daily work. So I maybe should have put this up front, but this is the U.S. definition of personal data. Personal data is also called personally identifiable information or individually identifiable information. And this is what we're worrying about when we're considering, what data might be regulated. Like I said earlier, it has to be identifiable to an individual, and these are the elements that may make it so. The Federal Trade Commission in the U.S., or the FTC, is kind of our fill-in enforcement agency for privacy and security violations. They typically, they enforce against for-profit companies, so it's not really something that you all would need to worry about, but their enforcement and their definitions can be helpful in considering best practices even for nonprofit organizations. So hand in hand with the FIPS principles, do you think this seems a little overwhelming, and how do I integrate these principles into my daily life and work? We talk about that using the term privacy by design, which really means integrating privacy into the life cycle of the data as it comes in, is stored, and goes out of an organization. So it's proactive and preventative. It's an organizational priority coming from the top. It's part of the design process of different programs, maybe coming from the bottom, embedded from the beginning when a new program is proposed. End-to-end, we talk about the end-to-end life cycle of the information, which means when it comes in, when it's stored, when it's shared, and when it goes out or is disposed of. And then it kind of goes into these FIPS principles also of visibility and transparency, accuracy, use limitation, security and safeguarding. And then a last thing to consider is data retention. How long do you want to keep that data? Are there any state laws that might apply? Even if not, do you want to set an organizational data retention policy to create a standard that applies to all data? Something that is increasingly used to implement privacy design is called a Privacy Impact Assessment, or a PIA. Some of you may have been involved in the effort that we went through with SAFE to try to institute kind of the first PIA and get feedback from members on how data is being collected and used and shared. To give you some background on PIAs, if you're not familiar with them, they are used by government agencies as a requirement of the Privacy Act. And they're required in Europe as well for private organizations, and increasingly in the United States, it's becoming a privacy and security best practice for private companies to engage in PIAs when they implement a new program that will be collecting or maintaining personal data. This is a high-level overview of a PIA approach in the residential context. It involves listing specific fields of data, and again, that goes to that FIPS data minimization principle. Kind of a practical question of how it will be collected, which, as we discussed, impacts what laws might apply to the data. If it's collected directly from an individual, as is typical, it would be less likely to be regulated by federal laws, but if it's collected indirectly, such as from an individual's care provider or school, it may be more likely to be regulated. And then you have this purpose specification, whether or not you're going to be sharing with others, which goes toward that notice at the beginning of letting an individual know before you collect the data, or at the time that you collect it, what it's going to be used for and who it's going to be shared with. That is a really big benefit to using the privacy impact assessment approach, that you are considering these questions at the outset or even before any data is collected, rather than trying to fix things at the end. And you find that you have collected data for which you didn't give appropriate notice, so now you can't in best practice use it for a different purpose. So you think about that resident choice, which goes to that FIPS principle of individual participation, whether it would be better to have them give an affirmative consent, or whether they could be able to just opt out of participating in a program or having their data used for a specific purpose. Unless that is regulated, typically opt-in is considered more of a safeguard of an individual's privacy. But in some cases, opt-out may be, practically the better choice, and that, goes hand in hand with that kind of gut check and, resident relations perspective. Are your tenants going to be upset that they didn't opt out and they weren't really aware that they could opt out and they weren't aware that their information was going to be used for this purpose? The privacy impact assessment would also talk about at the outset what kind of security and confidentiality safeguards you're going to apply to the data once you've collected it, who within your organization could access it and for what purpose. That would be particularly applicable in the situation where you're collecting data in conjunction with a lease, and then resident services would want to use it later on. Is that okay? If that's going to be happening, does the individual know about it? Then you have, incorporating what kind of oversight and training and accountability you're going to have within your organization. And the final principle that we haven't really talked about before is breach readiness. What happens if you're storing information online and you're hacked, or an insider in your organization uses it for an impermissible purpose, even though you've trained them, and you may have a rogue actor who takes an individual's financial account information and commits identity theft or something like that. Just an overview of the 6 main elements of a PIA, which is kind of more of an outline of the last slide. This is an outline of our approach when we did the Safe Outcomes Initiative PIA. This is just an example of how you would approach a resident services type of PIA. Again, going through the FIPS principles. So I think I'm going to pause there. It may be difficult with so many people on the phone, but I'm going to unmute and just see if anyone has any questions. The last part of the presentation, we're going to go through 5 different example scenarios that Juliana at SAFE very helpfully provided. And I will walk through kind of applying the FIPS principles and any applicable law that might be applicable to the type of data in the scenario. But that was a lot of information in a short period of time, so I just want to see if anyone has any questions. I'm going to unmute.
All participants are now in interactive talk mode.
There's quite a lot of background noise. I'm not sure if this is going to work.
Your line is now muted.
All right.
All participants are now in listen-only mode.
Unfortunately, I don't think that's going to work with so many people on the line. Hopefully everything was clear, and perhaps we can create a different forum at a future date where maybe participants could submit questions beforehand. I'm going to go through these 5 example scenarios, which are pretty detailed, and hopefully will give you an idea of how you might want to apply these principles in your daily work. First, we have scenario 1. A SAFE member is the property manager and co-owner of property A, which is undergoing redevelopment. Resident services are subcontracted to a third-party service provider. The SAFE member is conducting an eviction prevention strategy, whereby the property management staff identify residents in property A who have had difficulty paying their rent on time or in full in the most recent month. Property management may also identify residents in property A who have received lease violations that may jeopardize the resident's tenancy. These lease violations may be physical, for example, damage to the unit, behavioral, for example, a noise violation, or other. The property management staff share this information about residents in property A with the resident services staff, which, as you recall, are a third party. The resident services staff conduct outreach to these residents to address their housing issues and stabilize or protect their tenancy. Some residents may express frustration as they feel that their personal information has been shared without their consent. What is required here, and what are best practices? So, first we ask, what type of information is involved here? And going back to the scenario, we see that we have some financial information, such as rent payment history, and then we also have housing stability information, such as lease violations. And because these lease violations may be of the other category, there is potential that they could involve health information or education information or something like that. But these would be observed and directly by property management or received directly from by property management from the tenant or potentially neighbors. So the second, you would ask, do any federal or state privacy or security laws apply? And looking at this, it doesn't look at first blush, and again, not legal advice, but I don't see a hook for anything like FCRA, unless credit reporting information is involved here. I don't see any hook for other types of federal laws. So really, we're dealing with a best practices, FIPS, Fair Information Privacy Principles situation. So it seems that the problem here really is at the outset of the FIPS application with transparency or notification. It really would have been best practices here for property management to post notices in prominent places in the property, notifying tenants that their lease history or their rent payment history and lease violations may be used for this kind of purpose and may be shared with service providers of the property manager. It seems that the frustration on the part of the residents is in part at least due to the fact that the resident services staff is a third-party service provider, so they feel like information that is personal about where they live and how they paid their rent has been shared with somebody else. You wouldn't think that you would be prohibited from sharing information with a service provider, but these things can be prevented by just providing that transparency and notice in the first place, and that's why privacy by design is so important. Along with that transparency and notice, you would want to allow an opportunity for individual participation. So in that notice, you could provide an opportunity for residents to opt out of resident services. That may be done. You could also, if you wanted, provide an opportunity for them to opt in, which would obviously prevent this problem completely, as you could point to something that a resident had signed saying that they wanted to receive these services and that they understood that this information will be shared with the third-party service provider. And then as you walk through the FIPS principles and thinking about this type of project, you would want to ensure that your contract with the resident services provider limited their use of the data to the purpose specified. And again, that purpose specification would be traced back to the notice that you gave to the tenants. You'd want to limit the data given to the third-party service provider to the minimum necessary for them to perform these services. And then the last three principles are really organizational in nature, and I think don't go to the heart of the question. But the last one, accountability and auditing, including training, is an important part of implementing privacy by design and ensuring that these issues don't happen. Scenario 2. A SAFE member is the property manager, property owner, and resident services provider in Property C. The SAFE member also works with third-party organizations such as local banks or nonprofit financial counseling organizations to offer on- and off-site services to residents. The staff of Property C have found that many residents pay their rent using money orders rather than personal or bank checks. Since money orders are a wealth stripping tool, the staff of Property C have set a goal of helping 60% of the residents in Property C set up and use a bank account to pay their rent. The staff of Property C have identified a local credit union to help counsel residents on the benefits of owning a bank account and have offered to come to Property C to conduct workshops. Property C is a large community home to over 700 units. In order to target the residents most in need of banking services, the resident services staff would like to conduct targeted outreach to those residents who do not currently have a bank account. The property management staff at Property C collects this information from residents each year when residents complete their annual lease recertification, a requirement to remain eligible for HUD-assisted housing in Property C. The property management staff pull a report from their records that lists all residents and whether or not they have a bank account. The property management staff share this list with the resident services staff who, together with the banking partner, conduct targeted outreach to residents in Property C. While some residents are eager to participate in the banking services, other residents are confused and upset that the resident services staff and a banking partner that they are unfamiliar with appear to have access to their personal information. Was this permitted, and what are best practices? So by now, hopefully, you can see a pattern. Again, we have financial information that was provided directly by residents. It was not provided by the bank. It was given to the bank by the property manager and owner. So it's unlikely that any federal regulations such as FCRA would apply to the financial information. Instead, we are dealing again with the FIPS principles, and you can see that the problem here is with transparency and consent and purpose specification. The residents were not notified that their information when they recertified their lease could be used for these types of services. They didn't consent to it. They weren't given an opportunity to opt out of having it provided to a third party. I think most of us would be pretty upset if, even if it was for a beneficial purpose, if information that we provided for one reason was provided or shared with a third party for a completely different reason that we didn't even know about, and it's a third party that we're unfamiliar with. We have good intentions with these services, but a lot of this can be cured by just following these principles from the outset. It would have been best practices for the property to give a notice and an opportunity to consent or opt out to the resident at the time that they provided the financial information. And in the absence of having received that, they would have to go back and get it again. The other thing that jumps out at me here is that this targeting, even though it is a large community with over 700 units, may not have been strictly necessary. It seems like we're violating this data minimization principle here as well. Presumably there would be a different way to target outreach without using individuals' bank account information or sharing it with a third party, such as posting prominent advertisements in community spaces like laundry rooms, elevators, stairwells, any common areas, flyers under the door, that kind of thing. It does seem like a violation of residents' trust in their property manager that they would, use this information for a purpose that wasn't specified. So really, we're kind of dealing with not really thinking about the first 5 FIPS principles here. And while some residents are eager to participate in the banking services because, obviously they're well-intentioned and helpful, there is also a problem with residents feeling that their privacy has been violated, and they're not wrong. Moving on to scenario 3. A SAFE member is the property manager, property owner, and resident services provider in Property B. The SAFE member also works with third-party organizations such as a local health center or youth development organizations to provide on- and off-site services to residents. The SAFE member has developed a partnership with a local youth after-school program to offer after-school activities and homework help to residents in Property B. The SAFE member and after-school program provider would like to track the progress and success of program participants by conducting a pre- and post-assessment. Part of this assessment includes collecting and tracking student grades throughout the program. The resident services staff has recently collected student grades as part of a baseline assessment of the residents in Property B. Collecting student grades was a difficult process for resident services staff, as some families did not have report cards readily available. In order to eliminate the burden placed on residents to supply this information again, the resident services staff has decided to provide a report of the student grades directly to the after-school program provider. The provider uses this information to develop a tailored curriculum and to identify students who need additional support. This data will also be used to determine whether student grades improved over the course of the semester. Can they do this without informing students or parents of the sharing, and what are best practices? So here we have a bit of a different scenario. As you can see, we have education information and it's information about children. I mentioned earlier that FERPA, the Family Educational Rights and Privacy Act, applies to the privacy of certain education information, but only when it's held by a school that receives federal funding. It doesn't seem from this scenario like the property manager, owner, and resident services provider received the grades directly from any school or public school. It seems like eventually, even though it was difficult, the grades report cards did come directly from the families, and that they were given to resident services staff, which says to me that they were given in the context of providing these types of services. So I think there, you have the element of there likely is no federal law applying. You're starting out with FIPS, and you're starting out on a better foot than the previous two scenarios because that purpose, specification, and use limitation aspect is likely pretty in line with what the residents were notified of when the information was collected. A lot depends, and the information is not there, on what the resident services staff told the families about the baseline assessment that they were conducting. If they told them that it could be used in this context, and importantly, if it could be shared with a third-party service provider providing educational services, then I think you have a pretty good case that FIPS is being complied with, at least in the beginning stages. You would have the transparency. You'd want to ensure that you had some kind of individual participation in the choice. If this was required to be given the baseline assessment, you would want to give families the opportunity to opt out of sharing the information with a third-party service provider, even though it seems like it's all good and for the student's benefit. Particularly when you're talking about sharing information outside the organization, you want to be extra careful about making sure that people are aware of what you're doing. In this situation, it's helpful that the property manager, property owner, and resident services provider are all the same organization. But even within the organization, part of that data minimization and use limitation principle is limiting data to those who need to know and for the purpose for which it was collected. So I think in the first scenario, we had a resident services provider that was a third party, and that kind of raised two different issues. It's similar, if not quite as sensitive, when information is being collected by a property manager or a property owner for, especially federally required reasons, so the residents don't have a choice about providing it if they want to maintain their housing, and then it's being used without their consent and without giving them notice for another purpose. That would be a violation of the privacy principles. And I'd just like to point out that in each of these scenarios, we have a question about things that have happened already. And if we're implementing privacy by design and applying these FIPS principles at the beginning through a PIA or privacy impact assessment, issues can be avoided more easily. Moving on to scenario 4, a SAFE member is the property owner, property manager, and resident services provider at Property D, a senior community. The SAFE member's goal is to provide high-quality housing and services that help seniors age in place, such as access to primary care, fall prevention, mental health or social isolation screening, etc. As part of this strategy, the SAFE member conducts a comprehensive health assessment of each resident every year. The questions on the health assessment are designed to identify how vulnerable or frail the seniors may be and whether they are experiencing trouble completing activities of daily living. The resident services staff explain to residents that the purpose of the survey is to help develop programs and services that will help residents maintain their independence and dignity in their home. At each assessment, the resident services staff take notes on the information supplied by the resident and log these notes into a database. In a recent appointment, a resident asked to see the notes that the resident services staff has been collecting at each assessment. The resident feels that it is her personal information and that it should be shared with her. The resident services staff is unsure how to respond, as they have been instructed to keep all resident case notes private and confidential, including from the resident. What is required and what are best practices? So if we analyze this in accordance with our approach structure here, you can see clearly that we have health information involved. It's a health assessment. It is given by the SAFE member, which the scenario states is the property owner, property manager, and resident services provider. It's unclear if the SAFE member is a healthcare provider. I'm going to assume for purposes of this scenario that they are not a healthcare provider, that they are giving this health assessment in the context of being a resident services provider. So in that case, HIPAA would not apply. You would likely perhaps have a state law if it's in a state with a robust privacy regime, which includes California, Massachusetts, and Texas. Many states, including those, have medical information privacy laws, as I mentioned earlier, that apply to organizations that maintain medical records in the regular course of business, and you would want to look into whether this constituted that, and if so, look up what the requirements might be under your applicable state law. But generally, if we apply FIPS here, we can probably get to a place that would comply with most state laws. First, you have transparency, which it seems like in this case has been achieved. The resident services staff explained to residents that the purpose of the survey is to help develop programs and services that will help residents maintain their independence and dignity in their home. I would note that if that is in writing somewhere, that is even better. And all the elements of the program should be considered, including sharing that information with any third parties. As part of that notice, you would want to give the opportunity for individual participation. If the health assessment is at all required, to maintain the housing rather than being simply an optional resident service, you would want to make